everyone. Welcome to LexTalk, World Talk Show presented by ClickAway Creators. Once again, we have Mr. Khalid Adnan with us. He has been interviewed first, and we got to know a lot about him, about his journey as a legal professional. Today, we are going to dive deeper into what are his views on certain trending topics in the legal space. Let me just introduce you once again. Mr. Khalid Adnan completed his LLB from University of London with a first class in 2007 and his Bar Vocational Course from BPP Law School in UK in 2008. He was also called to the Bar of England and Wales from the Lincoln's Inn. And since 2009, he has started practicing law in Bangladesh. He has been engaged with more than 10 multinational and national companies as their legal advisor and panel lawyer. Also, Mr. Khan has been relentlessly working on the development of the laws of the road traffic accident and the clinical negligence cases, which areas are significantly underdeveloped in Bangladesh. So let's dive deeper into his complex, cases that he has dealt with and how did he supersede. There's a lot to talk about Mr. Khan today. So hello, Mr. Khan, how are you?
Hello, hi. Thank you for the very kind introduction. I'm fine. I'm fine. Thanks for asking. How are you?
I am absolutely amazing. Really excited for another round of interview with you. It's always a pleasure to have you with us. Mr. Khan, let's quickly discuss about one of the complex legal issues, because we have already talked about your memorable cases and your key takeaways from there. But this time, any complex legal issue that you would like to talk about, where you can describe the complexity and tell us how did you approach it?
Thank you, first of all, LexTalk, for having me back again. It's a pleasure and also it's an honor. And about the complex legal issues that you have just talked about, as you have earlier mentioned that I do deal with several issues of clinical negligence cases and road traffic accident cases. These are all tort law matters, but the jurisdiction where I practice, that is Bangladesh, over here, tort law is not that developed. Because of that, actually it's a struggle to work on these types of cases. Last time I was talking about a case that is still very close to my heart, and that's a clinical negligence case that involves the death of a 4-year-old child due to allegedly negligent treatment. I have been fighting that case for the last 7 years or more, and I'm doing that work on a pro bono basis. In the beginning, it was really difficult for me to establish, to fight these types of cases because of the fact that we don't have that much developed principles in this area. On a certain point of law, I lost the case in the magistrate court and then in the session court, because I wasn't able to convince the court that even if the law is not developed, it's high time that we develop laws in this regard. But I wasn't able to convince the lower part of judiciary so far as that point was concerned. So therefore, I went to the High Court, and there also I had to fight a very hard legal battle. Not because of the fact that the law was underdeveloped in that area, but also because of the fact that the defendants in that case are a pretty strong corporate giant of the country. And that's a very influential hospital. It's very hard to fight these types of cases for so many reasons that I'm not going to say in public over here. In that case, in the High Court division, I also faced some problems. Firstly, we don't have any definition of negligence or clinical negligence in our jurisdiction per se. That was a problem. And the other problem was the lack of judicial activism on the part of the judiciary. As we come from a common law tradition, the practice in common law tradition is that whenever we argue, we must be able to refer to earlier settled law. So when there is no earlier settled law in our jurisprudence or in our jurisdiction, it's difficult to convince the court on that particular point. Because of this thing, the matter was extremely complex. What I did was I referred to the case laws respecting clinical negligence of the UK and of India, where they do have pretty developed laws of clinical negligence. I invited the lordships to consider these principles from other jurisdictions. And I also invited the lordships um, to get involved in lawmaking, because as I have earlier said, we are common law jurisdiction. It's the task of the judges to make the law in the process of developing the law. The point that I basically argued, other than the legal points, that point was, if we do not develop laws in this area, the public interest at large will be at stake. I might be a victim someday, someone else might be the victim of clinical negligence. And this is also one of the fundamental features of rule of law, that everyone should be accountable to the law. The fact that I'm a doctor or I am a hospital, that doesn't mean that I can do no wrong. I was basically, what I was trying basically was to invite the judges to be active in the field, to make laws in the field, to develop laws in the field. And after month-long argument, I'm happy to say that I was able to win on that particular point of law. And the judges, the honorable justices of the High Court Division, they actually gave the judgment in favor of the child, of the deceased child. So that was a very good victory. And I would say that that's a very bold judgment in the history of Bangladesh, passed by His Lordship, Sir Justice A.K.M. Abdul Hakim and Madam Justice Fatima Nozib. They really passed a very good judgment in the area of clinical negligence, which I believe will shape the law in this regard in the future. And this case has already been reported in Bangladesh Law Times, and it's in the process of getting reported in other very popular law journals of the country. This is how I actually overcame a very complex situation where we didn't have any particular reference, but I actually needed a reference so that in the future, some other victim of clinical negligence can show that there is a case reported in Bangladesh Law Times or over there, and I can cite this case and I can seek relief from the court of law. It's very important from a common law perspective. Thank you.
Thank you. Thank you so much, Mr. Khan, for throwing light on this. It was amazing. I mean, I guess we've already talked about that. But this was like another level of insight. So thank you so much once again. Now, as we're already talking about the laws and how the legal industry works in Bangladesh, where do you see Bangladesh in international arbitration practice?
Actually, so far as international commercial arbitration is concerned, our jurisdiction is still struggling, I would say, and our law is not yet developed to the extent that we should be expecting. We have an Arbitration Act that was enacted in the year of 2001. And I'm proud to say that we are one of the countries that adopted the ancestral model law that was in effect since 1985. So Bangladesh is a country which has adopted the ancestral model law. So we have a good framework of arbitration law. That's the beginning. But the problem is, um, so far as I can recall, the law was last amended in the year of 2004. And now we are standing in 2021. By this time, the world of arbitration has changed rapidly. And so many laws have been enacted. So far as the ancestral law is concerned, that law was also amended, and it was amended in the year of 2006. Ancestral arbitration rules, they were amended in the year of 2010. The problem is our jurisdiction, our legal system did not incorporate those changes, those amendments into our existing domestic law. When arbitration would be the context, the major problem would be enforcement of awards. And if the domestic legal system cannot provide an efficient system of enforcement, in that case, the foreign investors or the foreign party, they would not be comfortable in dealing with arbitration where enforcement would have to take place in Bangladesh. That is one of the aspects I believe where the government should put its eye on, and the government should be thinking about that. Apart from that, I would say that in 2021, right now, we have a very advanced international arbitration system throughout the world. Even in India, arbitration has developed significantly in the last, I would say, in the last 5 to 10 years. A lot to learn from them as well. There are so many laws that are not here in our domestic law framework. We can learn from international organizations like ICC, that is the International Chamber of Commerce, CARC, Singapore International Arbitration Center, LCIA, London Court of International Arbitration, to name a few. I am mentioning these names because they have also got very advanced arbitration rules. We need to learn from those rules, and we need to incorporate some provisions of those rules into our domestic law in order to make our laws more aligned with the international arbitration law. In international arbitration, basically, we are talking about one single industry. Obviously, it involves a lot of countries, but if we cannot make our law or our legal system uniform in terms of the overall attitude towards international arbitration, I believe that we would not be able to reach where we want to reach. It's high time, I would say, that we should be amending our laws, we should be making changes to our laws in view of the laws that have already been amended. This is not a very difficult task because we can look into the laws of Singapore, Hong Kong. They are also Asian countries, but they have got a very good international arbitration legal framework. We can easily just look into those laws and see what's missing. And we can then think of incorporating those ideas into our arbitration law framework. There have been so many concepts, new concepts, I would say, that are emerging, like the concept of emergency arbitration, expedited arbitration procedure, and so on. These provisions are not present in our domestic law framework, but these provisions are there in the legal framework of international community. I believe that it's high time for us to look into these areas, to make changes, to incorporate some amendments. And the objective should be to make the law more advanced, more effective, and more efficient. Given the fact that now foreign investors are thinking of investing lots of money in this country towards the development of infrastructure, I believe that commercial disputes in larger scale will happen very soon. If we don't have a very good international arbitration framework, in that case, what will happen is we'll have to go to other countries to resolve these disputes, which do have a very good international arbitration framework. I would humbly say, or I would recommend that the government should be looking into these areas and should be working really hard to make these areas compatible with the international jurisprudence.
Thank you so much, Mr. Khan, for throwing light on the arbitration practice in Bangladesh. But when we have already talked about arbitration, can you please also throw light on the mediation practice there?
Yes, thank you very much. Mediation is again significantly underdeveloped in Bangladesh. So far as the international ADR concept is concerned, mediation is growing vastly. We have got laws of mediation. We have got Section 89A of the Civil Procedure Code, which specifically states the provision regarding mediation. So it's very much within our civil jurisprudence and civil jurisdiction. The problem is not having law. The problem is having its application. It's not like we don't have law, but I would say we don't have the application. What is the reason for that? The reason I would say is lack of awareness about ADR and about mediation. Lawyers should be more informed about these areas. Bangladesh has got a very adversarial legal culture, I would say, where people, the litigants and the lawyers, they prefer courts to settle their dispute. ADR is a concept which provides us an alternative forum for resolving our disputes rather than going to the court. There are so many problems with the court because there are issues of cost, delay, complexity when you're going to the court to resolve your dispute. When you are dealing with your commercial dispute, when you are dealing with dispute which requires quick disposal, I believe that ADR should be your forum rather than the courts, because courts would not be able to give you a quick, speedy disposal of your issues. From that end, I believe that mediation can be very effective. Throughout the world, it's developing, is growing. You can look into the Singapore Convention on Mediation, and many countries have signed that convention, which speaks for the enforcement of mediated settlement agreements throughout the world, or in the countries where who have signed this convention. Bangladesh hasn't yet signed that convention. I believe that it's high time for us to sign that convention, because when we sign that convention, when we ratify that convention, I certainly do believe that that will change so many things, because when you sign your convention, you'd feel the need to change your domestic law in line with that. Right now, we do not have any special law regarding mediation. We have some mediation practice, like we have got some cells, like mediation cells of rehab, mediation cells of the cantonment board. In my opinion, they all are using the evaluative model of mediation. Throughout the world, the model that is being preferred is the facilitative model. But the model that we are using in most of the cases, in my opinion, those are not facilitative mediations. Those are rather evaluative mediation. It's high time that we learn the difference between what is evaluative mediation and what is facilitative mediation. It requires a lot of training as well. It's not just a matter of raising awareness, but everything would have to start with the raising of awareness and then with proper training as to what facilitative mediation is. lawyers and litigants, they should be aware of the fact that mediation can be really helpful to resolve the dispute amicably without going to the court or without going to the arbitration. And this is a very powerful, efficient, and cheap process that the parties can adopt, and they will be in control of the whole process. If people get to know about this, if the lawyers are informed about this, I believe that mediation practice has a very good future in Bangladesh. But above all, I would highly recommend that the government should sign the latest Singapore Convention on Mediation, because I consider that to be the equivalent of the New York Convention of 1958, and that helped us to recognize arbitration with no domestic framework. And I believe if we sign this mediation convention, the Singapore Convention on Mediation, that would help shape the future of mediation practice in Bangladesh. Thank you so much.
Thank you. Thank you so much, Mr. Khan. I'm sure viewers will get a proper, insight on how the arbitration practice and mediation practice looks like in Bangladesh as of now. Sadly, we are coming to an end of this conversation. But before I let you go, I just wanted to ask this, like time is money in any profession, right? And in legal, it's most of all. So how do you ensure to make the best of your time as a legal professional?
This is something to think about. And this is not just about my profession, this is about human life. When I go to the graveyard, suppose, and I look into the graves, I just see two sentences in every tombstone. That is the name of the person who is inside the grave and the timeline. Say, for example, 1950 to 2005. The way I view it is like there are just three information on the tombstone: the name, the birth date, and the death date. And we do not have any control on either of any of this. We don't get to choose our name. We don't get to choose our birth date. We don't get to choose our death date. But these are the three vital information that we don't get to choose are written on the tombstone, which represents us after our death, the only physical existence, I would say. What is most important is the dash between those two timeline, the birth date and the death date. The dash, that's the time that we have got. That's the thing that we have control over. That's the thing that make us what we are. And that's the thing that will make us what we will be. Obviously, we don't get to choose our time, but we get to choose as to what we will be doing in between. And obviously, we don't know when we will die. So it's very important that we don't take our time for granted. It's very important. And it's very important to always remember that every moment is valuable and precious, because it can be the last moment, who knows. I watch cartoons a lot. And one of my favorite cartoons is Kung Fu Panda. Over there, if I can properly recall, Master Oogway, before departing to the spiritual world, says something which still touches me. That is, yesterday is history, tomorrow is a mystery, but today is a gift. So we don't know about tomorrow. We can't change our past, but what we can do is like we can work on our present in order to make a better tomorrow. I believe that this is not just for the lawyers, this is for everyone. And that's my opinion on time. Thank you.
Thank you. Thank you. The problem is that we all think that we have time, but actually we don't. So thank you very much, Mr. Khan. It was a lovely conversation yet again. And it's always, something or the other to learn from you. And after this interview, I am taking a lot of things from you. So thank you so much once again for that. We'll stay in touch. I'm looking forward to more interviews like these where you get to share your experience and knowledge with us. And for our viewers, if you like this chat with Mr. Khan, please like and share this video. And do not forget to subscribe to ClickAway Creators YouTube channel to appreciate what we do. And you have more coming from industry legal leaders like Mr. Khan. This is Bharti for LexTalk signing off. Take care. Bye-bye.